Thank you. Karen, you're on.
Good evening, honorable legislators. I'm Karen Baer. I'm the Director of Human Rights. And to my left is Xavier Rusk. He is the office's paralegal aide. So first, I'd like to provide you with a schematic of what we call at OHR the building blocks of our philosophy for promoting and protecting human rights in Tompkins County. You may have seen this before, but it is the foundation for how we think about this work and the programming that and the services that we try to provide. As you can see, at the core of protection is the civil rights enforcement. At the core of promotion is the human rights education and outreach. The stepping stones, so to speak, that guide us include collaboration, partnership, and bridge building strategies. And our desired outcomes look like healing, celebration, and dialogue. And of course, in order to sustain this work, we need community support and a government that is responsive to the voice of the people. So our major goal this year is to engage in a meaningful and public conversation around the issue of restoring local enforcement powers for the Office of Human Rights in order to better serve the citizens of Tompkins County. We'd like to share with you some of the distinct examples of how we've tried to emulate and implement these ideals in the last year and going forward. In terms of education and outreach, 2016 is marked by the 29th annual Human Rights Arts Competition that is currently underway. It is our very popular K-12 art and poetry competition that attracts over 500 students countywide each year. The program encourages kids to express through their artwork what they find meaningful about the 30 articles of the Universal Declaration of Human Rights, signed by the UN member nations more than 50 years ago. On December 10th each year, on International Human Rights Day, we celebrate and showcase the winning entries and artists in a recognition ceremony. It's a lot of fun for students, teachers, and families, as well as OHR staff. Partnership. In the fall of 2014, OHR joined forces with the Advocacy Center of Tompkins County, the Cornell Law School Global Gender Justice Clinic, and the Tompkins County Human Rights Commission to bring attention to the issue of domestic violence in our community. This collaboration led to the drafting and promotion of a resolution recognizing freedom from domestic violence as a fundamental human right. By the spring of 2015, and after numerous public engagements, circulated petitions, focus group surveys, interviews, and lobbying efforts, each municipality in Tompkins County, including the county legislature, the city of Ithaca, and the Tompkins County Council of Governments, passed resolutions declaring freedom from domestic violence as a human right. The passing of these resolutions was a very significant achievement, but the work did not end there. And going further and forward, it became our goal to provide a meaningful and practical framework for implementing the ideals expressed in these resolutions. Our new objective was to provide employers, both public and private, the necessary tools for successfully putting those words into action. The results of that continued effort produced a domestic violence and workplace model policy and a private employer's toolkit. This important work continues as we plan to create opportunities for training and networking around these materials and this issue. Collaboration. The Tompkins County Office of Human Rights and the Human Rights Commission have joined a statewide coalition effort called the Statewide Source of Income Coalition. Coordinated by Erase Racism New York and comprised of dozens of organizations and businesses from across New York State, that are supporting an amendment to the New York State human rights law to expand the protected classes to include lawful sources of income, such as wages and salaries, and federal, state, local, corporate, and nonprofit assistance payments or subsidies. In other words, this amendment would extend housing discrimination protections to individuals utilizing housing choice vouchers, otherwise known as Section 8 vouchers, Social Security, supplemental security income, unemployment insurance, spousal support, veterans benefits, and the like to cover housing costs. Currently, it is not unlawful to discriminate against applicants that receive that pay their rent through those types of resources. Before moving on to enforcement, I want to emphasize that one of OHR's FTE positions, the Program and Outreach Specialist, is generally responsible for these efforts that I'm talking about. The position has been vacant for nearly a year now, so it has become a necessity for the remaining 3 staff members to take up the slack on these and other outreach-related activities. Enforcement. After a period of time where the paralegal position was also vacant, we had the great opportunity and the great fortune to hire Xavier Rusk in that role. He has done an amazing job of fitting into our small staff culture and taking over key responsibilities for intake, referral, and other important tasks related to enforcement. As you can see from the pie chart, the majority of the complaints we are seeing are employment-related, almost 40%, with housing complaints taking up 25% of our caseload. Public accommodation complaints come in third at approximately 16%. It may also be of interest to you that 33% of all complaints are based on disability, with race and color continuing to be a frequently alleged basis of discrimination. And according to our data over the last decade, retaliation in the workplace and in housing continues to score high in terms of complaints of discrimination arising in Tompkins County.
I'm sorry, could you go back 2 slides? I couldn't read.
This?
No, the one before. Oh, yeah, that one. What are the wedges?
Oh, dear. What happened?
So the orange wedge are non-jurisdictional cases, and the purple wedge is education cases.
What does non-jurisdictional mean?
Non-jurisdictional means that someone's come in and they're alleging a complaint, for example, so there's only 5 subject matter jurisdictions under the anti-discrimination law. They include volunteer firefighter. Okay, so as an example, if someone came in alleging a complaint about DSS mistreating them, that would be something that's not under the 5 protected categories that are like housing, public accommodation, volunteer firefighter, and employment. Education is usually protected federally now by the OCR, but we do still see cases like that coming in, and we assist and make referrals when necessary.
And are there percentages attached to those wedges?
Yes.
Both are 5%.
5?
Thank you.
So I think I missed something there. So there are only 2 wedges? I thought I was looking at 3.
Enforcement is 5%. Non-jurisdictional is also 5%.
And that line between,
It's got a,
little line, thing in between the 2. Does that have another wedge?
No, those are just 2 wedges. I'm sorry, I can't see it well on my screen either, but
Peter, does it have to do with this slide?
So That is another wedge. That wedge right there in the very center of the two is 0%. That's what we're seeing for volunteer firefighters. And the reason why it's showing up like that is because there's a data difference between the type of program we used and the type of program on this computer.
Peter.
While you have that slide up, I don't see what the label is on the bottom hemisphere and on that the brown hemisphere and the purple quarter sphere.
Employment is 49%, the large chunk, and up above to the right is housing at 25%. Public accommodation is above to the left at 16%.
You can read it easier.
Peter,
No,
yeah, it's on the handout sheet.
I see. Okay, thank you.
it's hard to.
Go ahead, carry on.
Sorry about that.
Clarification of that as well?
Is it about this?
Yeah. So is this chart, we have the power to enforce gender discrimination here locally. So is this where you see gender discrimination? Which realm, in the housing realm, in the employment realm, or does this include the gender discrimination that we handle locally and these types of discrimination that you help people apply to the state?
Yes, well, this is the more appropriate chart. We haven't received any complaints based on that protected category. Okay, correct? And, but it would show up here in terms of a protected category. And if you've been following the changing laws, sexual gender identity and expression is now being enforced by the State Division as part of the gender that was passed, the gender law that was passed in January, took effect in January, the Gender Equality Act. So now it is also unlawful to discriminate based on gender identity and expression. It's a violation of the state human rights law.
Carry on.
Major influences. We see one of the major influences that's challenging is the lapsing of the Memorandum of Understanding with the State Division, which really limits our local enforcement capabilities. We have seen a drastic reduction in filed complaints of discrimination in our county after that point, and we do not believe this decrease is due to the sudden absence of discriminatory behavior in the workplace, housing, and places of public accommodation. And due to the narrow protections found in the current local law, OHR is limited in how it can assist persons in Tompkins County who feel they have been discriminated against. Many human rights stakeholders continue to express dismay when they are told by our office that we lack jurisdiction over many of the issues that we previously addressed or that they believe we should be continuing to address. The impact of the county's hiring freeze on our department was significant over the last year. Prior to the hiring freeze that took place last year, 2 of my 4 FTEs resigned after being offered pretty impressive career opportunities elsewhere. Then the hiring freeze was enacted before we were able to fill those positions, and this meant that 50% of my staff positions were vacant for a period of time. And we are still trying to recover from this. Our hope is to be fully staffed again by the end of this year. Limited opportunities for staff training in 2016 because we were unable to utilize the unspent funds for training in 2016. We couldn't take advantage of enforcement training that was intended to provide us with some opportunities prior to securing some local enforcement powers. Hopefully, we will be able to achieve this in 2017. Our office space continues to have an issue of accessibility in terms of especially mobility accessibility. And those are priorities for us, and we hope that this year that can be resolved in terms of making the Human Rights Office fully accessible to persons with disabilities. And there are racial and ethnic and gender bias anxieties out there in response to some of the local, national, and global events, including an increase in community and police conflict and an increase in bigoted discourse stemming from the ongoing presidential campaign, terror attacks, all exhibiting negative racial, ethnic, religious, disability, and gender-based undertones. And after this election, I believe there will be challenges, regardless of who wins the election. There will be challenges for agencies like ours. So this is what we call the boring slides. Just the numbers. I'm sure you have those. The recommended budget. 4 full-time employees. Our over-target requests, which is for training that we had hoped to do this past year, but we hope to look forward to spending those monies for enforcement training, fair housing testing, and other things related to our main goal, which is to reestablish some enforcement powers for OHR. And in addition to that, this is something that our office subscribed to when I arrived. When I became aware of the limited enforcement responsibilities given the lapse of the MOU, this kind of database was something that we let go because the use of it wasn't really that prevalent. But as we look forward to possibly reinstituting some of those enforcement activities, this definitely will become an essential tool to the work that we do. And I'm also open to the possibility that there are other offices in the county that do subscribe to these legal databases, and if there's a way to be added to a user list at a more reduced cost, I'm open to that possibility as well. Thank you very much.
Mike, Dan, Peter, Martha.
Thank you, Karen. I was a little curious about this statewide source of income coalition, though, just because we were literally having this discussion yesterday or a couple days ago. And frankly, that's a pretty big policy discussion. And I'm a little concerned that we've actually already joined something through the county. And that's kind of my concern, because we were literally only talking about choice vouchers in Section 8. And this goes all the way into, like, unemployment insurance. And it just seems to me that that opens a big can of worms for a lot of people who are, like, landlords. Like, are we not going to be able to do checks on possible tenants? Can you actually even afford this apartment? I mean, according to this, that would be discriminatory. If I were to say, well, do you have a job? And then they said, no, I'm on unemployment insurance. Are we saying that people would not be able to then say, well, you're not going to be able to afford this apartment? I mean, that's kind of what I'm getting out of this. I mean, this seems to be a pretty big policy discussion that the legislature kind of should have. Well, I don't know how it would come out, but it seems like that's pretty big. And it seems like the commission's already joined it. So that's why I'm curious.
Well, first of all, there's a number of questions that you raised. One is that source of income protection doesn't mean that a landlord or a housing provider can inquire into the ability to pay. It's just that the law says now that even if someone is able to pay, but they pay through a Section 8 voucher, that they can be discriminated against, because even though they can pay and it's a legal form of payment that landlords can exclude based on that. And some of the studies that we've done at the office have shown that a preponderance of people who use those vouchers belong to protected categories. For example, disabled populations, female heads of households, race, national origin. All of those, the statistics show that they are more likely to use those types of subsidies for their housing than others. And so it has a disparate impact. The policy of restricting tenancies based on where your source of money comes from is a real barrier to housing.
But do you understand what I'm saying, too, that that's kind of like a policy discussion? That's not a...
Well, in answer to that question, all I can say is that we're often engaged in these kinds of things. We also associated ourselves with GENDA, and we're part of the statewide movement related to gender identity and expression being added to the protected category. And this group, which is just now being formed, we're just now trying to find support throughout the state, and we haven't developed yet an actual strategy for how to go forward. A lot of communities already have source of income as a protected category in their local laws. So it's a type of protection that has been used by communities based on, their situation and their needs. And I'm guessing that the state will probably move towards that at some point, but I'd be glad to be a part of any discussions that you have on policy and contribute in that way and be helpful. And if we find later down the road that there are issues that are unsupportable in terms of the strategy or the outcome, I'm open to having those discussions.
Dan.
I wanted to ask for some clarification on what you listed as your second major influence, the impact of the county's hiring freeze on your department. My memory is the hiring freeze lasted a few months and was over a year ago. So can you clarify how that's affected you?
Yeah, well, I had 2 positions that resigned just, in July. The hiring freeze took place in August, I believe, the hiring freeze. That was right at the point where I had 2 vacancies. And I couldn't hire because of the hiring freeze.
August 2015.
Okay, yes. So what happened was that, in fact, we had gone through the process of canvassing for the paralegal position, and I was working with personnel to do that, and then we realized we couldn't hire Xavier because of that restriction. So we waited for a bit, and then Joe did give his permission to hire for that position, and we're very grateful for that. Xavier came in October, just prior to the lifting. I think the freeze was lifted by late October, I think. So, and then I still had another vacancy. And I had made an agreement with Joe that I wouldn't hire that position until January, which was after the hiring freeze had lifted, and I honored that agreement. And so then we went through. At the beginning of the year, we canvassed for that position and did interviews, and it rendered a very, a great candidate, and we offered the position. And after 24 hours of considering it, she turned it down because it was not enough. The salary she realized wasn't enough to meet her family needs. So then we went back to the drawing board, we looked at the job description, we recanvassed, we're in the process of interviewing now, and we hope in the next few weeks we might have a full staff, so we're really excited about that.
I'm glad to hear that. I'm just curious why you cited the hiring freeze. That I'm not clear what.
Well, what it
because the county's hired dozens of people since January. I'm just curious.
Well, what it meant for us, because we're a very small staff, and it meant that for a period of time, I was doing all of the intake, I was doing all of, and I was restricted from participating in other kinds of things that I would normally be doing. And it really, for a small office, it just had a really big impact on, who did the work, how the work was done, what kind of work we didn't really have the resources to engage in. So we did give up some opportunities because we just didn't have the staff. And so for me, it was one of the major impacts of last year was this, this whole sequence of events.
Thank you.
Peter Stein.
Hi. I believe I heard something. I looked through the sheets here and I couldn't find it, but I thought you said in the beginning that recently the state has expanded its definition of things that can be protected against, and I don't remember whether or not you listed what these things were, and so I was wondering what was that expansion?
Okay. Well, one of the expansions is familial status and employment.
Was what? I'm sorry.
Familial status.
Familial status.
And employment. It previously only applied to housing, meaning that you couldn't discriminate against families with children. And now the state law says that you can't make inquiries into that status in employment as well. Okay. Another addition is related to domestic violence victim status, which previously only applied to employment. And since January, it now applies to housing. So
what does that mean? Just take an example of housing and domestic violence, how that hangs together.
So, for example, there are embedded in many leases this provision that if law enforcement is called to your property a certain number of times, that it's considered a violation of your lease.
Okay.
And some housing providers have used that in cases of women who call the police for protection in situations related to domestic violence. And it's actually, you see it more often than you would think, because it's dealt with broadly as a violation of the lease. Mm-hmm. But now these, and it's predominantly women that are impacted, are protected in housing and in employment situations. The other is gender identity and expression. The Gender Equality Act made it unlawful for harassment based on gender identity and expression. So it's treated very similarly now to sexual harassment, both in the workplace and in housing and in public accommodation. And it remains to be seen how these types of complaints are going to be adjudicated since they are relatively new. But those are the additional protections that we saw come into play starting January. Are there others? I think that's it.
So that's a redefinition of what's meant by gender, I guess, or it's added to the mix or something like that.
Well, sex refers to male or female, okay, and gender refers to how you express that.
Okay. All right, thank you.
I have Martha, myself, and Carol Chalk.
Thank you. So Dan asked a couple of my questions about the hiring freeze. But in your answer, you said that, and I don't remember how long the freeze was on, but you said
3 months.
Xavier came in before the freeze was over.
Yes, I said that Joe allowed, I think it was 2 weeks or so before the freeze was lifted. I was authorized to hire Xavier.
Okay, great. So, and I understand it's important to wait till you have the right person and all, but the freeze has been over a long time. So the question on the slides on the percentages on enforcement, you got 2 slides. You've got percentages. Can you help us with it either now or send us later? The round pie charts. The question is just, can you give us the total number?
Yeah, this is based on 81. The caseload was 81 cases.
The total caseload on that slide was 81. So that's the same caseload for the next slide?
Yes.
Okay. Oh, it's on there.
And I have to explain that when there are cases, we haven't got the data back yet from the state, but there are people that filed directly with the state division, and we wouldn't necessarily know that they filed unless they go through our office. So we're waiting on the data for how many residents of Tompkins County actually filed housing, public accommodation, and employment complaints directly with the state division. And then routinely we ask the U.S. Department of Housing and Urban Development to also share that data with us in relation to housing.
Okay. So next slide then. The protected categories. Is that the same number then?
Yes.
Okay. And your office is on the first floor. Isn't everything is on the first floor? So what's inaccessible about it?
The doors at the entrance. And so in order to get into our office, you basically would have to call ahead, because the door on the sidewalk opens outward and it's not automatic. And then once you get inside the little lobby, then our suite door opens outward. So, I mean, if we have a client that is in a wheelchair or has other mobility disabilities, we can arrange that, when we set up appointments for them, we can arrange to, but somebody just, we generally call them walk-ins, but that's probably not appropriate in this case. When somebody just wants to come into our office from the street, there's some significant barriers there, and if sometimes they've looked on our signage on the front door, gotten our phone number, called us in the office and asked if we could open let them in.
Right, so drop-ins. So you would, I understand, we rent that space, right? We rent
Yes.
it, okay. Has that been discussed with the landlord?
We're starting discussions now, working with Jackie Kippola to deal with some of the, I guess what you would call the, I forget the violence in the workplace measures, and to address all of those issues. And that certainly was on our list. And, we're supposed to be, the landlord is now taking care of some other issues that are on that list. And I'm pretty sure he thinks that the door is, an electric door, for example, an automatic door would be prohibitive. But I think my strategy is going to be to at least ask him to get some estimates so we know what we're dealing with, and see whether we can somehow make that accessible and make it affordable.
Thank you.
Carol, I'm going to have Carol Dooley and Will and Mike go, and then I will go at the end. Go ahead, Carol.
So, two things. I'm confused about the staff numbers. So, do you have 4 slots currently filled in the office?
I have 4 FTEs.
And the one you don't have?
When I'm fully staffed, I have 4 FTEs. There's the director, the receptionist, a paralegal aide, and a program and outreach specialist.
And which one is vacant?
The program and outreach specialist.
Okay, thank you. And then this office has a rich history in our community, and I place particularly a high value on ensuring, as I've seen you do it, actually, it's really interesting to hear about this, the ways in which you're working, we work, county works to ensure that our residents are well educated about human rights issues, whether they be employers or employees, landlords or tenants, et cetera. And I place, and that they have a local place to go for help if there are individual issues as well as the general education. I'm trying to understand the part of what you said. If we're unsuccessful in bringing back some of the powers that this local office used to have, are you saying that then you won't be able to spend a lot of this budget? Or there's enough to do whether or not we get those powers back?
Yeah, well, the way I see it is that the office is set up in a way that we have the human resource to do the enforcement piece. It doesn't mean additional staff. It doesn't mean, it does mean some training and some, continual training in these matters, but that we have the capability of doing that enforcement piece now, okay? So it's true that all my OTRs, all of my requests are based on the fact that we hopefully will change that scenario, that the office will be reinstated with some type of enforcement mechanism so that people that have complaints in our county don't have to go to the federal or state government. Currently, we're trying to be a go-between between those larger agencies and local complainants. And I can't even imagine what it would be like for them to do that on their own.
No, I agree. That's why.
So the issue is that, and if you don't know, what happened previously is that we would have power to, to file a complaint, to do intake, to do conciliation, to do an investigation, and to make a finding. Okay, so currently, we can't do any of that right now unless, for some reason, both parties agree to submit themselves to that kind of local process. I don't have a mechanism. I don't have a statute. I don't have anything that gives me those jurisdictional powers to investigate local complaints. And people are, sometimes people don't realize that, and we're criticized for not doing it. Some people, aren't aware how limited our local law is, and that it doesn't, provide protections for all of those categories. So it's a kind of a fine line that Xavier is engaged every day with people with appointments and trying to assist them, because we have to refer our complaints to either HUD or the State Division of Human Rights. And it takes, it's a difficult process for most. And we're glad we're here to assist people, but it would be so much easier for citizens if they had a local enforcement mechanism instead of having things investigated over the phone and through faxes and other sorts of investigative from a distance techniques.
Karen, excuse me. I want to jump in here just 1 minute. You mentioned a local enforcement. How many counties in New York State, first of all, have human rights offices that do local enforcement? There's 62 counties, roughly.
Right.
And how many do that, local enforcement?
Well, Geneva has a local fair housing law that I enforced while I was there. That was the only FAP in New York State that wasn't a county.
That's a city, right?
Right, that's a
Okay.
city. There are varying degrees of human rights agency types present in New York State. Some assist the state just in intake. Some have some types of local laws. I know that Westchester County, Rockland County have local enforcement, and they have MOUs with the State Division and with HUD. And there probably are a number of other counties that enjoy that status.
Let me get back to Dooley.
Yes, thank you. You have as your major goal for the year what's being talked about now, the reestablishment of local enforcement. And I'm wondering what indications you have that the state may be looking favorably on this.
Well, local municipalities have every right to establish its own local laws.
So it's doing it through a local law, not through a memo
Right.
with the state.
Right.
That's
I'm open to, I'm open to a local law which provides some local enforcement powers for residents in Tompkins County. I'm open to, and we've made another movement towards the state to encourage them to reinstate our MOU. I'm not sure about the likelihood of that, but we are exploring that possibility. In many ways, that's the ideal possibility. If we could re-engage the state with an MOU and be an arm of the state, it would return the status, the kind of status we had prior, and that the state and the local office would work jointly on the adjudication of discrimination complaints, where the hearing would be the obligation of the state and not the locality. So I'm mostly interested in talking about it, having a discussion about it, what enforcement might look like, what it wouldn't look like. For me, if next year provides an opportunity for the community to start discussing about, do we need it? Maybe we don't. And if we do, what does it look like? And if it's there, who does it protect? And what is the process? And I'm interested in having that discussion at every level.
Is that the kind of discussion that the commissioners would be part of?
Yes, but it's, for example, the commission certainly has a stake, and I do know that they support, local enforcement powers. But this is something that the powers that only can rest in the county, in the office, in the department of the county.
I wanted to say that, Xavier, I think you were at the MPO meeting where their Title VI plan was discussed, and I was very impressed with your familiarity with it and your suggestions to them. So I'm very glad you're on board. And Martha, thank you for asking the question about accessibility. I was very puzzled by that, and we should not let that continue.
Will.
And actually, this is building on Martha's question. I was trying to figure out, you said you need to talk with your landlord. I was trying to find in our budget book what we were paying for rent at that site, and I was astounded to find on page 139 that the rent is zero. But I'm guessing that it may be embedded somewhere else.
Yeah, no, that's not.
That is definitely not correct. It's thousands of dollars. So
Do we know?
I'm somewhat protected from that because the administration takes care of that. Jackie Kippola does that piece, and she often engages with the landlord about, the negotiating the lease and such. So, but I have seen the lease, and it is.
I fully believe you, but it's just puzzling.
Kevin, Joe, are you looking it up there?
Is it in facilities budget? Is that where we put the rent for this building? I'm not sure if it's in the human rights budget or if it's in the facility.
I've never seen it in my budget.
Yeah, I think
Thank God.
I'm looking at facilities right now to see if I can find it there. We'll get you the number. I recall it's in the $12,000 range, but
Okay,
my
and
memory is not
sort of a related question. Do you, and while we're looking, I'd be curious what our lease arrangement is and how long we're locked in at that point. Thank you.
Okay, Mike, Loveland, after that.
Hi, Karen.
Hi.
Really pleased to hear that you're trying to reengage the state about the MOU. I think that's very, very important. I think they've punished us long enough for things that happened before you came on as director. And the fact that there are MOUs in other areas similar to what we used to have seems to me that it would be appropriate to get that kind of authority back. More concerned about local enforcement, like that direction, because basically it would seem to me, and you can comment on this, wouldn't it make us give us a prosecutorial role in these kinds of things rather than the assembly of the information and moving it on? Wouldn't it open us up to potential litigation if we make mistakes? I'm concerned about that.
Well, litigation due to mistakes is always a possibility. But the models that are used, for example, the model that I used in Geneva, which was approved by HUD, is similar to what happened here. The local office did intake, investigation, served the parties, and gathered the evidence. They made findings and determinations. The only difference under the model that's more generally used is that if you only have a local law that's not an extension of the state, that you do have to create an adjudication piece for after a finding. And what that generally looks like is, for example, when you're dealing with housing, it's called the Fair Housing Board. It's 3 members who sit on a board and they hear the evidence, and only after they decide is there actually a finding of guilt or innocence, okay, in terms of violation of the local law. So in Geneva, that's the experience that I have. So the way it worked there was I never, out of 100 cases, not one of them went to a public hearing because of my emphasis on conciliation efforts. And I was always able to get the parties to come to an agreement or to conciliate prior to a hearing. And I think that's usually the best way of settling these issues. Not to say that Tompkins County would be the same, but the local law that I have drafted, the proposed law, has that piece in there that addresses what happens to a complaint after there's a finding of reasonable cause. And yes, it's complicated. Yes, it's long and tedious, but the process is very transparent embedded in the proposal of the local law. It does mean that we would be responsible for that added piece that the State Division previously performed in terms of adjudicating a human rights complaint. And if there are, my ultimate goal was to kind of use that local law because once the EEOC, the Equal Employment Opportunity Commission, sees that a locality has a local law that looks like the Civil Rights Act, they're more likely to have an MOU with us. Okay? So, and HUD is the same way. You have to have a local law that looks like the Fair Housing Act, substantially equivalent to the Fair Housing Act, before these federal agencies want to use you as an extension of their process. And so part of my strategy is to create a local law which does mirror federal and state protections, and then find ways of partnering with those entities so that we can bring resources. Now, when we did this with the State Division, we never got paid for the work that we did. We were performing all of those duties up into public hearing without any subsidy, without any payment. Okay, so in theory, the county was paying for all of that enforcement with local dollars. If you have an MOU with the EEOC or with HUD, that comes with some resources. Okay, either for training or for enforcement purposes. I think that it would be in the state's best interest to actually engage with us and allow us to provide those services for them. I'm not sure whether we could get into an MOU, some kind of payment for those services, but, and maybe it's a non-starter, but I would like to engage, have that discussion with the state to see what an MOU might look like, and what kind of relationship we could have, whether it's similar to the one we had previously or if it's something that's really more beneficial to the county in terms of being paid for the services that we provide.
Thank you.
Leslie.
Thank you. Some of my questions got asked. I appreciate you all doing that. Mike, I'm not sure what you mean by the state is punishing us for things that we might have done, but maybe you'll explain that to me at some point.
I'm glad to. That's the way it appears to me.
So I'll be curious to hear that. And Karen, goodness knows we are well aware that we were not getting any money from the state because every year we whined about it. We're doing all this work and the state does not pay us any for it. But we realized that it was extremely important to the people of Tompkins County that we maintained doing that work because often their cases got lost in a black hole, whether they were going to New York City or to Binghamton, and we wanted to make sure that our people here were getting services as quickly as they can. I want to talk a little bit about the local law. Even with our memo with the state at that time, if my recollection is right, and don't quote me on it, we would take the complaints, do the investigation, determine whether there's probable cause, but then we still have to send it to the state. We still sent it to Binghamton. They would say yes or no. From everything that we have, it seems probable cause, and you proceed to whatever the next step is. Whether people want to conciliate or whatever it is, you go back and forth before a hearing examiner or something, or an administrative law judge or something. If we get in place, if we enhance our own local law that we have on the books right now, so we have one that covers gender issues. what do we do now if there are complaints that come that violate our local law C or our local law that we have in the books? What do we do now? I thought we already had a framework for what we do now.
There's somewhat of a framework, but I think you know that the local law only protects based on gender identity and expression and sexual orientation.
Right.
And we've never had the opportunity to use the local law because we haven't received any, since I've been there.
Since you've been here.
Since I've been here, I haven't received any complaints based on that protected category.
And you have not seen anything that says what's the framework for what happens if we have a complaint in that?
Yeah, I know what the local law framework is, and Xavier, you want to, are you interested?
No, I don't need,
Okay.
right. I was just wondering if there was something that already, and I shouldn't wonder if I know there's something that already exists. Can that same thing be in place if we have the enhanced local law? Instead of trying to recreate something, can we use the same process that we have in place now?
Mm-hmm.
So I would say that the framework that's created in the local law, if we were to expand it to where the subject matter jurisdictions covered things like along the federal and state lines, and also the protected categories, those things like gender, race, color, all those things expanded to there, there is a framework within it for us to work with. However, the issue of investigation, the issue of making a finding, the issue of being able to actually enforce and the law doesn't really exist there. Like if a respondent, for example, if we tell a respondent that they have to respond to our inquiry because there's a complaint against them, if they choose to ignore us, there's nothing that we can do without a local law that says that if you ignore a subpoena from us, there are consequences. That's not in our current local law, the consequence part.
Okay, that's what I'm trying to get at. So what we need to do is we can enhance our local law, and then we need to have that additional enforcement consequences piece added to whatever the framework is, so that people know this is what's going to happen if you don't. So we have it step by step. I just wanted to get a sense of what's happening now. Thank you for that.
I've waited long enough, and then I'll go back to Julie and Peter. Karen, there's a OTR for 14.9, and it's training for enforcement staff. So there's an assumption that we're going to be in the enforcement business. Is that what I'm getting from that?
Well, at least we're going to be trained for it. I mean, the training has to come, I would like the training to come first.
Right.
Okay? I wanted to do that last year, couldn't really do it. So this year I'd like to focus on capacity building my staff so that when we get some kind of, opportunity for local enforcement, that we can do it and we can do it well.
I have Julie and then Peter, and we'll take a break and come back. No. Julie, go ahead.
I just wanted to say that Will piqued my curiosity about the rent, so I looked in Appendix B under Facilities, and there is an entry, Irish LLC, Human Rights Rent, $28,975.
What page is that, Julie?
B4.
B4. Thank you very much.
Yep.
And someone else had their hand up. Peter.
Yeah, Karen, I have a couple of questions to try to summarize what I remember as the MOU and what went on. And let me just tell you and then ask you if that's correct. It was my understanding that in the days of the MOU, when there was a complaint, we, meaning your office at that time, would investigate that complaint and write a report where they came to a conclusion of some sort, and they would then give that to the state, and the state would say, well, thank you for the report, and we would use that report as the basis of bringing it to court or whatever you call it, okay? That's what the MOU is about. Is that correct, more or less?
More or less.
More or less.
Yes.
And so, and if we wanted to do it ourselves, then we would have to give ourselves two things. We would have to give ourselves the investigation. We have to figure out who's going to do the investigation. And then we would also have to, by ourselves, carry out the trial, so to speak. And we need that. We need that expertise, which is different than the investigation. It's like the police and the district attorney or something like that. So it would seem to me that all of these things cost money, and there's nothing you can do that doesn't cost money. If you're going to have a small police force and then a small court, you know, some people get paid, and that the cheaper thing would be if we could get the MOU in, because we wouldn't have to provide the adjudication part. Is that more or less correct? That
more or less.
Okay, thank you.
Anna, last thing, okay?
Absolutely. So I'm clearly on a steep learning curve. So this question might, I'm still trying to put all the pieces together. I'm glad that both of you are here. So the 15,000 is training and the testing. And given the current context of what everybody's been talking about the law or lack of pieces of and enforcement, the training I understand. The testing is to build an understanding of what the current climate is. Is that the context, is just to understand the climate? Isn't there an enforcement part within that?
Yes. There's two types of testing. There is audit testing, and there is enforcement testing. So when we, if you recall, when we were doing the analysis of impediments to fair housing choice, we did 30 fair housing tests for audit purposes only, which meant that the tests that came back positive were not adjudicated. They were not considered the basis of complaints. They were purely for auditing purposes to do what you suggest, which is to get a sense of the climate of the community, what kinds of barriers are there, what kind of discriminatory acts are taking place and to what degree, just for, data purposes. The fair housing testing that we're proposing here is not for audit purposes. It is for complaint purposes. So, say for example, we do the 15 tests, and we see it's analyzed, and it turns out to be a positive paired test that shows some form of discrimination. Then we would refer that complaint at this point, because we don't have any. If we had local enforcement powers, we could address it way more effectively. But at this point, we would have to file a complaint and send it to a state or federal agency.
And that goes to HUD?
Yes.
Okay.
But there's also a possibility of conciliation. One reaction to a positive test would be to go to the housing provider and make them aware that the test took place. We could provide educational training, whatever is necessary in order to prevent it from happening in the future.
Okay. That all is coming together.
Thank you very much. I think we're finished with OHR now.